1 in 3 contested probate cases in England and Wales involves a creditor claim that the deceased's family has never heard of before the death. I know this statistic because I spent 8 months living inside one. My mother built her business over 22 years, a small but profitable florist and events company that she had started from a market stall when I was 6 years old and grown into something real: premises, staff, a reputation. She died in March. The business was the primary asset in her estate. It was worth, according to the valuation obtained at the time of probate, approximately £240,000. Under the terms of her will, it passed to me, her only child, along with the remainder of her estate. 6 weeks after the grant of probate, the official permission of the court to administer an estate, a man I had never heard of contacted my solicitor with a creditor claim. He said my mother had entered into a partnership agreement with him in 2016. He said the agreement entitled him to 40% of the business's net value on her death. He produced a document. The document bore my mother's signature. I'm telling you, this is an exhausted story. I want to be accurate about that from the beginning. There is no dramatic reveal that wipes everything clean. There is an outcome that is better than the worst one, and a cost that does not go away, and a question about my mother that I will never fully resolve. The man, I will call him Gerald, was in his late 60s, recently retired from a related industry, and presented himself as a former business advisor who had helped my mother during a period of financial difficulty in 2016, when the business had nearly failed. He said the partnership agreement had been the basis on which he had provided support, financial and advisory, during that period, and that she had always intended to honour it but had allowed things to drift, and that he was now simply seeking what had been agreed. He had a document. The document looked legitimate. My mother's signature was on it. It was dated the 14th of March 2016. I sat in my mother's business, in the back office, where she had kept the paperwork, surrounded by the smell of the place, cut stems and cold water and the particular dusty warmth of a room where someone has worked for a long time, and tried to understand how a document existed that I had never been told about. 2 minutes in. I need to tell you something about grief and legal processes. Which is that they do not coexist well. Grief is not linear. It does not respect hearings. You are asked to make decisions about the future of things that belong to someone you loved, while the loss is still acute, while you are still reaching for your phone to call them before you remember. And at the same time, you are supposed to be a rational actor in a legal dispute, reading documents, taking instructions, following procedures. I was not always a rational actor in this period, I want to be honest about that. There were hearings I attended running on 4 hours of sleep. There were documents I signed without reading as carefully as I should have. There was a settlement offer I nearly accepted because I was exhausted, and the business that my mother had built for 22 years was sitting in uncertainty, while this man's solicitor sent letters. Francis, my solicitor, patient and absolutely unmovable, told me not to accept it. She said, "You have not seen everything yet. Wait." I waited. The midpoint arrived when the document examiner submitted her report. Francis had commissioned a forensic document examiner to review the 2016 agreement. The examiner's report noted that the paper had characteristics consistent with being produced in the correct period, but that 2 of the clauses used legal terminology that had not entered common usage in partnership agreements until approximately 2019. The examiner's conclusion was that, while she could not determine definitively that the document was fraudulent, she had sufficient concerns about the drafting consistency to recommend further investigation. The further investigation produced Gerald's witness. Gerald had named, in his initial statement, a former business associate, who he claimed had been present when the agreement was signed and could confirm its authenticity. The associate, a man called Norman, provided a written statement confirming that he had been present. Norman had been content to provide that statement until Francis contacted him directly and asked him some questions about the specific date of the meeting he recalled. The questions were careful. The answers were inconsistent with the date on the document in ways that Norman had not prepared for. On the 3rd day of the hearing, Norman revised his statement. He said he could no longer be certain of the precise date. He said he had been relying on Gerald's account of the timeline. He said, under questioning from Francis that was surgical in its patience, that he had, in fact, not been present at the signing, but had been told about it shortly afterwards. Not present. The witness, who had confirmed the document's authenticity, had not been in the room. The judge found that Gerald had not discharged the burden of proof required to establish the validity of the partnership agreement, and that the document could not be admitted as the basis for a creditor claim, given the questions raised about its authenticity and the revised witness evidence. Gerald's claim failed. The partial win is this: I retained the business. I retained it in the form my mother left it, without a 40% carve-out to a man who had produced a document from 8 years ago that nobody in our family had ever heard of. The costly part is that the process took 11 months. During those 11 months, the business operated under a cloud of uncertainty that cost me 2 significant event contracts, both of which cited instability in the company's ownership structure as a reason for withdrawal. Those contracts were worth approximately £47,000 in revenue. They are gone permanently, and the question I carry is one I cannot answer. My mother had a difficult year in 2016. The business nearly failed, and she never told me how bad it got. Did she receive help from someone during that period, and was the help real? And if it was real, did she agree to something she later regretted and chose not to tell me? I do not know. I will never know. She is not here to ask. Gerald had a document with her signature on it, and his witness turned out not to have been present. That is what I know. It is not the same as knowing he was lying. It is close to it, but it is not the same. What do you do with a question about your mother that she took with her? I'm still working that out.